Good evening, everyone. On behalf of Gaillard Bani Michel Barrière Disputes, I would like to welcome you to the third Gaillard debate. Those of you who have been with us since year one, the idea is to organize a true debate, polarized, around one question. International arbitration. This year is the finality of Arbitral Awards, an essential attribute of international arbitration. What we have tried every year is to find a topic that would have interested Emmanuel Gaillard and that he would have opined on somehow, and to confront that with his views, for the theory and the sake of it. So tonight, I will not introduce, I will leave that to our dear Diego and Marina. I just wanted to say thank you for being here, welcome. And just one word of logistics. We will have the cruise at 8:30 sharp. The boat leaves at 8:30 sharp, so you're on it or not. If you're on it, you go. You need to retrieve your coats before you go and then leave your coat in the boat or the yacht or whatever it is. And it's going to be a 2-hour cruise over the Seine. And we're very lucky because we almost not had it because of the level of the river, which has now gone back down, and we can safely have a cruise. So thank you for being here, and you're in very safe hands now. Thank you.
So, good afternoon. I'm going to present you our speakers today. Maybe first I'm introducing Diego Arroyo, that you all know, who is the president of the Arbitration Academy. And today we'll have a debate between Benjamin Sinault, who is a founding partner of Gaillard Bani Michel Barrière Disputes law firm, who is a specialist of enforcement of arbitral awards. He notably dealt with the enforcement of the very famous UCOS case. Benjamin is one of the creators of the website of the UNCITRAL on the New York Convention. So he collected decisions from all over the world and translated them and commented them. So he's really a specialist in the field. And is also a very active president of the Paris Arbitration Week, amongst many other tasks that he has. And we have today as a very special guest, Shane Spelisi, who is the director and legal advisor at the Law Bureau of the Government of Canada. He, in this quality, has been advising Canada on its obligation under investment treaties and advising Canada on its international arbitration proceedings. He's also Canada's delegate at the UNCITRAL, and he has been elected chair of the working group number 3 on investor-state dispute resolution. So that's only a few words, but those are our speakers today. And the debate today will be about the finality of arbitral awards. As you all know, the fact that arbitration is a one-shot dispute mechanism is one of the great advantages that we traditionally, we consider that it's one of the great advantages in arbitration because in terms of efficiency, in terms of time and cost, of course, it's a plus compared to local proceedings. And also because on the substance, when you choose arbitration, for instance, you choose a specific arbitrators that will be neutral, and you want to be sure that the decision of the arbitrator will not be overturned by a local court. So even on the merits, this is a very strong advantage to stay out of the local court system. But on the other side, it's true that sometimes we are faced with bad decision, bad arbitral decision. This also happens. And this has brought the lawmakers to consider whether we should not think about installing an appellate mechanism even in arbitration. So we will discuss about this today, and I will give the floor to Diego for further introduction or the first question, maybe. Do you want me to start?
No, I think this is okay. We wait a little bit technical solution? Okay. No, I think we could go directly to our debaters today. You know, there are swords here that is. I hope that is not the case, that we have some blood in the scenario today. But at the beginning, Shane and Benjamin will expose for 10 minutes around his positions, their positions on this, and then we will start with the real debate. So, Benjamin,
Fantastic.
if you wish to start.
I think the first question was, is the finality of arbitral award a key attribute in arbitration today? Is it still a key attribute or not, and why?
Oh, thank you very much, and thank you, Shane, for coming and for the debate. It will be a gentle debate at the beginning, but I think that maybe we should start with some introductory remarks, because we've discussed this a bit with Shane at the beginning, at the outset, and just to be clear on what's the nature of the debate. Here we're talking about whether or not finality is an essential attribute. So we should be distinguishing, I think, what we would call normal advantages of arbitration from an attribute which basically defines the essence, what touches upon the intrinsic definition of the concept, the institution. So if you start with that, you may want to say that some advantages that you know, confidentiality, speedy resolution of process, capacity of maintaining good relationship during a dispute, cheaper, we may disagree on some of those, but those are often raised as advantages of international arbitration. Now, finality could also be considered as an advantage, but it could also be considered as an attribute, such as neutrality of the arbitral tribunal, choice appointment by the parties of the arbitrators that they have decided to choose. Now, so that is the first point I wanted to make, because we may disagree on what, for instance, that confidentiality is actually an attribute of international arbitration. That was argued. Emmanuel Gaillard already in the early 2000s was making the point that confidentiality was not so much an attribute of international arbitration. It was something that was provided for expressly by the parties if they choose so. And eventually, in the reform of 2011 in France, it was decided for international arbitration, confidentiality would not be amongst the features of international arbitration. So we're talking here about an essential attribute which defines arbitration, international arbitration, so not domestic arbitration, as a whole. And we're talking about international arbitration, which most of you know is not a defined concept, but we're not distinguishing between investment, commercial. It's going to be a global debate today about that. But if I was to give my sense of a definition of international arbitration, as it is often taken, is the consent of the parties to settle, finally, their dispute through a third party that they have chosen, who is independent and neutral and outside the domestic system. So if you take that basis, this will illustrate a lot my position today in potential appellate system that may be considered. Now, we're talking about finality of arbitral awards, and as you also know, for those who attended my course on the New York Convention, is that the arbitral awards are not defined, and were not defined by the drafters of the New York Convention. But if you look at the case law, and this was also highlighted by the Ancitral Secretariat Guide on the New York Convention, it may be agreed that an arbitral award is a decision that decides finally all or part of a dispute, whether on jurisdiction, on merits, and all. And that is also a definition that you can find in different domestic systems. So, now we get to finality. Finality, the way we're going to argue it today, is the fact that an award may not be appealed or revised on the merits. It's very important because there are some debates as to whether or not setting aside and or correction of awards or clerical mistakes goes against finality. I think we both agree that finality being lack of appeal on the merits, it provides, so in the concept of finality, there's the fact that there is a limited review by courts of domestic systems, so the courts are not excluded. Often this is a criticism that is provided against international arbitration, whether or not there would be sufficient review, and it was always the purpose of maintaining a limited review, but not on the merits of the decision, but on the integrity of the system. And that is something that I think is very important. So now that I've clarified these concepts, there is my position, and the way I'm going to argue it today is that finality derives from the intent and content and consent of the parties. The parties, when we know that arbitration is a creature of the parties, they decide how they want to solve and resolve their disputes. Well, when resorting to arbitration, parties choose finality. And it's not petition, it's the way in practice you can see this happening. How did they choose finality? But first of all, in their arbitration agreement, when they decide to enter into an arbitration agreement which provides that they will finally decide their dispute going through specific arbitration. It can be an ad hoc arbitration or relying on arbitration rules which themselves provide for finality. And if you look at the most successful and most used arbitration rules, whether the ICC, the LCIA, the SCC, SIAC, all ancestral arbitration rules all provide that the awards that will be rendered, most of them use the decision that the award that will be rendered is final and binding. Some of those rules also add the fact that the parties waive their rights to any form of appeal. So you see that by choosing to govern that the arbitration will be settled by applying these rules, this is also a manifestation of the intent of the parties to having this finally decided. So, of course, these were examples I provided in commercial arbitration. But the same could be said from investment arbitration. And if you see the number of BITs that refer, some doctrine mentioned there's hundreds of BITs. I've seen a few of those preparing this conference, and in all regions in the world, whether in Africa, whether in Asia, and you see the same words that the award that will be rendered is final and binding. And it's not only the BITs, it's not only bilateral treaties, you also have multilateral treaties. And you know Article 53 of the Washington Treaty Convention provides that the award that will be rendered is binding, final and binding. So all of that, and you also have the ECT, Energy Charter Treaty, and so on and forth. So by choosing arbitration in practice, in the overall majority of the cases we've seen, the parties choose finality. And their choice and their consent to arbitration and their intention for this award to be rendered to be final is also protected by domestic legislation, because you've seen throughout the years, you see amendments to existing legislation, which, if you looked at it in early 20th century, was much provided for, sometimes for appeal, for domestic arbitration, or even for international arbitration, and progressively was amended to guarantee finality of arbitral award, i.e. no review of the merits of the case. And so that is a perfect transition with my point, is that the corollary of finality is the absence of appeal on the merits. And that is very important. So either it's expressly provided in arbitration rules, it can be implicit, for instance, in the New York Convention, or for the ICSID, you see that there are limited grounds for review for recognition and enforcement, or through the ad hoc committee process. So it's limited ground, and if you look at the case law rendered by domestic courts or by the ad hoc committees, it is it is widely recognized that these recourses prohibit revision of the merits of the award. And if you look at just French, we're in France, so if you look at French case law, it's been consistently reaffirmed that courts should not review the merits of the decision rendered by the arbitral tribunal. So if you have that in mind, we then forget that why all these principles were set. What was the purpose of finality? And finality is key to the efficiency of international arbitration, to have an efficient, effective enforcement of arbitral awards. And we need to go back into how the system was at the Geneva Convention. At the time, an award, once it was rendered, was deprived of any binding force. It could be enforced only after a party had exhausted all local remedy at the seat of the arbitration. That's what you got, the double exequatur. And at the time, finality within the meaning of the Geneva Convention was that there was no more recourse against the award. And that is the reason why in the New York Convention, in Article 5.1e, the drafter decided to take out finality, not because they did not want, they were against finality. They were against the concept of finality as it had been developed in the Geneva Convention. The point of the drafter was that once an award is rendered, it should be enforced in an expeditious manner, as fast as possible and with the least obstacles possible. So if you take that in mind, and bearing in mind that once the parties, by choosing finality, also choose that they are bound by the arbitral award once it's rendered and should comply with that, and you come and look at the case law which has been developed by domestic courts pursuant to the New York Convention, and or by ad hoc committees in the context of the ICSID, you'll see some principle that once an award is rendered, there's a prima facie right to recognition. That is provided under Article 3 of the New York Convention, and this was the case, this was a decision, a very clear decision by the High Court in England in the Yukos Oil versus Damana case, which provided that this prima facie right to recognition. But you find the same wording, you find the same language in decisions of ad hoc committee. If you know the ICSID system, you can not appeal, but you can bring action against the award through ad hoc committee, and the ad hoc, once you file your request for annulment, the enforcement of the award is automatically suspended. But then, if the party challenges the suspension, it can raise issues as to whether or not why the award should be enforced pending annulment proceeding. As you can see in a consistent manner in ad hoc committees, which, by the way, have been much more reluctant in maintaining stays throughout the years, that there is a presumption that the award is final and that it should be enforced in an expeditious manner. So I think I may have done 10 minutes, but I think that my final point here before we launch the debate is that finality is not only an expectation of the parties, but it is also necessary to ensure an effective and independent dispute resolution mechanism, which is key to the development of international trade in a multilateral context. Thank you very much.
Thank you, Benjamin. Just before Shane take the floor, I just wanted to specify that the position taken in this debate today are also for the exercise, so they do not necessarily fully or completely reflect the position of the parties that are here or of the entity for which they are working for.
So you're basically saying I didn't mean what I was saying.
Thank you. And good evening, everyone. Thank you to Diego and Marina, our moderators, of course, for having me here tonight, to Yaz, for her team, for organizing this. I think it's a wonderful event and a wonderful opportunity to address some of the questions that the great Emmanuel Gaillard, in whose honor we're here, liked to discuss and liked to debate. And I don't know, Yaz would know better. Perhaps he just took positions without really meeting them as well in order to get the debate going. But obviously, I think this is a very important issue, and I'm going to argue one side of it. As Marina has said, it's not necessarily what I believe. In the context of UNCITRAL, I like to say that I have my opinions, but as the chair, nobody gets to know what they are, because that's not my role. So what I'm going to be presenting here tonight is in response to the question we've been asked, which I think is perhaps maybe even a bit deceptively simple. So is finality an essential attribute of arbitration? And for much of actually what Ben has said, I would actually agree with. The definition of what international arbitration is, and in a sense, I think most of us would have a simple reaction. Of course, arbitration, an award must be final. It can't be enforced unless it's final. All awards must be final and binding. But at one point, Ben had said that the corollary of finality is it cannot be subject to an appeal. And here, I think, is where I would engage in the debate and disagree. Because I think that what that statement contains is actually an assumption about what the content and the concept of finality includes in arbitration. And it's an assumption I think is unjustified and would suggest that it is unjustified basically for one of the reasons that Ben himself hit upon, which is choice. I certainly don't dispute that the lack of an appeal against an arbitral award is something that many, if not most, parties to arbitration agreements have specified. You will find it, as Ben said, you'll see it in rules, in legislation, in treaties, and in contracts that awards are in fact not subject to appeal. But I would suggest that the fact that you will see that in the past doesn't really answer the primary question here, which is finality an essential attribute, or is the non-appealability of an award an essential attribute to arbitration? I often hear in the context of discussions of reform that some attribute X or attribute Y must be an inherent attribute of arbitration because that's the way we have done it in the past. My response to that is usually pretty simple. The fact that we have done it that way in the past doesn't mean that we are required to continue to do it that way in the future. There is a difference between something that is a practice, something that we have done, versus something that we are required to do by the very nature of the concept. Choosing arbitration without any sort of appeal is in fact just that. It is a choice. Arbitration, I would suggest, permits other choices to be made. And I would make 3 points on this. So first, the concept of finality is, I think, not quite as definitive as Ben has presented. I would suggest that it does not mandate that there be no appeal on the merits. Second, the practice that we have, as I said, I would agree that for the most part, it has not allowed appeal, but in fact, there is practice that does allow appeal of arbitral awards. And that can show us that, in fact, different choices are possible. And I think if we focus on the nature of the choice that has been made, we can see that the different choices are possible is reflected by the most essential elements of arbitration, which I would agree with Ben, include choice, party autonomy, and consent. So let's just start with the first point about finality. And what do we mean when we say an arbitral award is final? This is not a discussion about other types of dispute settlement, but I would note, of course, the concept of finality is not unique to arbitration. In our domestic systems, we have final judgments. A judgment is often considered final when it resolves all the issues, that it ends the action, unless, and this is a big unless, it is subject to some sort of appeal within the confines of the procedural rules that exist. As understood for the most part outside, I would argue that the inherent content or concept of a final judgment is that simply it is the last from the court which resolves the remaining issues, and it must be complied with unless an appeal is made. And in fact, if you look in many domestic systems anyways, appeals are expressly only allowed or only allowed of right on final judgments. So I would say that in fact, the concept of finality, at least as it's generally understood, is much broader than simply meaning that there is no appeal. Finality allows a much broader content within it. The question then comes is there something then special or different about international arbitration that would lead us to have here a different conception of finality? And I think if we look at both the practice and what has happened and the understanding of arbitration, we will see that there is not. So first, as a matter of practice, as I said, I agree entirely that for the most part, arbitration parties have chosen, or the parties to arbitration have chosen not to have an appeal. But that is not always the case. Ben mentioned that there are some types of post-award review possible. So for example, in the ICSID system, he mentioned that we have annulment proceedings. Under the UNCITRAL process, we have, of course, set aside under the model law. You can challenge recognition and enforcement. These are all post-award remedies. And in fact, some of them could be seen to be addressing classic things that you would appeal. So for example, if you are in a domestic court and you don't agree with the decision of jurisdiction of the first instance tribunal, what do? You appeal it. In the context of arbitration, of course, that can be a grounds for set aside or annulment. But this is, I agree, this is not an appeal on the merits. I raise it not because I suggest that it is appeal, but to suggest that when we talk about finality, we do accept that there is some post-award review possible, and that award can still be final. And I think that should lead us first to question, okay, well, why are we drawing the line at appeal on the merits then? Why is that the line that we are drawing? And can't we then, if some post-award review is possible, couldn't the parties then choose to draw, in fact, a different line? And I would suggest that we can, and this brings me to my second point, which we do have examples of systems, procedural rules, whether they be institutional or domestic law, where appeal is possible. I don't profess to be an expert in any of these, but I understand under the English Arbitration Act, there is a right of appeal on questions of law. Under the Australian Commercial Arbitration Act, parties are allowed to appeal an award on a question of law with court leave if both parties opt in. The rules of the Spanish Court of Arbitration were actually amended in 2011 to introduce opt-in provisions for an internal appeal mechanism. And even the European Court of Arbitration rules provide for an internal appeal mechanism to an appellate tribunal. I don't mean to suggest that these are all the same. They could be very different. The point that I'm trying to make here is that in practice, what we see is already there are parties or there are jurisdictions that do choose to answer this question differently, that in fact an appeal is possible. We have examples even in the arbitration community. We have the Court of Arbitration for Sport, which has an appeals division. I understand it to be, again, a slightly different context, but it shows that there is a concept or a content here that could be different than what we have done. It shows that, in fact, what we see in the past was a choice made by arbitral parties not to have appeal, but that it is not some sort of inherent aspect of arbitration. This then will bring me to my final point, which is the fact that a choice of appeal is consistent with the most basic principles in arbitration, which I think I agree with Ben, are party autonomy, choice, and consent. He offered a definition right at the very beginning, which I don't disagree with. I would just disagree with what the assumption is on final. The important thing is that this is a private form of dispute resolution, so outside the courts of a party, that is entered into at the request and with the consent of the disputing parties to go outside the local courts. The essential attribute, in my mind, is the choice of the parties to opt in. And it's that element of party autonomy that I think we should understand extends beyond the actual agreement to arbitrate. So I think it would be relatively uncontroversial to say that in an arbitration agreement, the parties have the right to choose their own procedure. I would suggest that the corollary of that really is they have a right to choose a procedure also that involves an appeal. There may be parties who, for reasons I think that Marina mentioned at the beginning and that Ben has mentioned, who prefer not to have an appeal, who prefer, in fact, whether it's for efficiency, value, moving quickly, and that could be reflected in arbitration agreements. But there may be other parties who prefer some other method of review, an appeal of some sort, because they value correctness or consistency more than they value efficiency or getting a one-shot type of decision. I would suggest that, in fact, one choice is not more arbitration consistent or more arbitration-like than the other. They are, in fact, both evidence of the key aspects of arbitration, which are the consent and the party autonomies. And in fact, what I would suggest is denying parties the ability to appeal is inconsistent with those principles if, in fact, they choose to allow an appeal. Thank you. I'll leave it here.
So I will go to you quickly because if I understand well, you are saying that appeal is possible and parties could have the take the decision to go to an appeal if they want. It is, according to you, a part of their party autonomy, finally. And so if that is true, what kind of appeal we should have? So what shape it would take, according to you?
I guess I would answer that partly in starting by coming back to sort of the question of party autonomy. It's probably limited only by the imagination of the lawyers drafting the arbitration agreement as to which it is a part. The possible procedures are really quite varied. There are obviously a number of things that you need to think about. You know, to whom are you appealing? What issues can be appealed, the scope of appeal, as well as the standard of review that would be selected. You know, in terms of what the procedure would be, we have, and I gave the examples, there are some that allow for appeals already on questions of law to domestic courts. the English system. I understand the Australian system. If you do allow an appeal to a domestic court system, then I would think a lot of the questions that you might have are going to be answered by the relevant domestic legislation. So obviously, to appeal to a domestic court system, the domestic court system is going to have to accept appeals. You can't just show up to any domestic court and say, I'd like to appeal an arbitration award. There has to be some hook in the domestic legislation. But if the domestic legislation does allow that, it's likely, I would say, that it probably also sets out the scope of appeal, the standard review. Those are questions the parties may not need to answer. They will simply have chosen to go to the domestic court system for appeal. Other types of appeals could be possible as well to standing tribunals in the international context, whether existing or created. And if it is a standing tribunal or a body that's created, I would suggest many of the same questions would likely be answered by the statute. So that statute would likely set out the mechanisms for which bodies, which appeals it could hear, scope of appeal, standard review. Obviously, it also will accept, and it will have to be some sort of agreement creating the body as to what its scope of jurisdiction will be. Can it hear cases only from other standing mechanisms, from independent appeals or independent tribunals? But I also point out that aside from that, it's also possible for parties to design their own ad hoc appellate mechanisms right in the arbitration agreement itself. They could, in their arbitration agreement, select for a second panel, which would be appointed in any way they wish, charged with any scope of review, could have, whether it's review on the facts or merits, whether it has standard of review that says, manifest error, all of these things are open for the parties. In terms of sort of looking for examples, one interesting thing one can look at for sort of that ad hoc approach to individuals, one can even look at some of the investment treaties that have recently been signed, like the Canada-European Union Investment Treaty, which actually contains clauses and has rules of procedure adopted for an appeal mechanism. This is in an investment treaty, it's between two parties, but what we have here is essentially an ad hoc agreement that within the arbitration appeal procedure, there will be an appeal permitted. And it sets out all of the answers to these questions. But I do think those are the primary questions, and I think that the options are probably quite varied at what you could do.
Okay. And do you think, Benjamin, that it's possible to reconciliate the existence of an appeal, as Shane proposed, and the finality? Or what, we can change the question, what that system should have in order not to undermine the finality of the award?
So reacting just in a few words to what was initially done, so we're doing a proper debate, is that finality in the sense that we've been using is revising the merits in all or in part. So if you take finality in this way, then question is that in light of the different appellate mechanisms that exist today, I believe that those would undermine the concept of finality as that exists now. I fully agree with Shane on the fact that it's a question of choice. Parties are free to decide on an ad hoc basis or by deciding to settle their disputes through an arbitration or at least an institution that provides for appeal. So I think that it's very important. I've started by saying that arbitration is the creature of the parties. Parties could decide to structure the process in the way they want. Now, when you look at a lot of the debates and the reform of the system, whether on commercial arbitration, on investment arbitration, it is often references to institution and or domestic law that provide for some limited appeal, because most of the appeal that are being contemplated are not de novo appeal in most of these institutions and or domestic courts, such as the English system. But then I started looking at those, and the question I'm raising is whether or not the intent of the parties by providing by this two-step process is actually to resolve their disputes through arbitration. We would not be asking this question if the parties decided, for instance, to have conciliation first, non-binding mediation. There would be a decision, which is non-binding, and by definition, the parties would be free to resort to arbitration. So I started looking at, for instance, the AAA institution, or I think you mentioned the European Court of Arbitration, which are two systems which are often raised, and I realized that in fact, the decision that is made in these rules is that the award that would be rendered in, let's say, first instance is not final. It's conditional. It's provisional. In the sense that, yes, if the parties do not appeal that decision, it will eventually become a final award. That is provided under the rules. Now, if there is an appeal that is triggered, then the parties agree, first, that the award is not final within the meaning of, and that is, for instance, what is provided by the American Arbitration Association, which provides in its beginning that upon the filing of a notice of appeal, the parties agree that the underlying award shall not be considered final for purposes of any court action to modify, enforce, correct, or vacate the award. So it is not final. It is provided that the decision that is rendered is not final. It's also provided that the decision itself is non-binding. It's subject to review, and the parties have no obligation to enforce it. So you start thinking as to if it's not binding, if it's not final, and I would advocate that it's not an award according to the New York Convention, Article 1 of the New York Convention, then is it really arbitration? And this started me thinking, because when you look at the European Court of Arbitration, which provides the same system of first instance decision, which is conditional, which can be appealed, there it's a bit more complicated, but at the end I realized that the parties agree in the arbitration rules that if such an appeal is filed, the victorious party, by accepting these rules, undertakes not to enforce the first instance award, which is fine. You could decide, pending a certain event, not to enforce it. That may not necessarily affect the finality, but then to replace the appellate award to the first award. So the award, the first award, whatever we want to call it an award, which is non-binding, non-final, is replaced by the intention of the parties. That becomes non-existent. And so we have a system where the parties have predetermined that this first decision that will be rendered by the arbitrator may, in some circumstances, be deprived of any binding effect on the parties, any possibility to enforce it. And so if you take back the definition of arbitration I gave you at the beginning, to finally settle the dispute through a mechanism by third parties that you have chosen, you're losing a lot of what I would consider to be the attributes of international arbitration. Now, what I found much more interesting is CAS, so of course the Court of Arbitration for Sports, because if we go back to history, CAS did not have an appeal system at the beginning. You had what would say the ordinary procedure, where a party would decide to rely on to have an arbitration through CAS. There would be an award, final award, which could be set aside before the federal tribunal. That was the easy part. And then there were the federation, sports federation, which would render a disciplinary decision, which would settle their disputes. But that would not be an award. That was a decision. And that decision could be appealed to the second chamber, and that second chamber would render a final award. And that final award could be challenged before the federal court. Now, the system has evolved because the CAS has created chambers, first in '96 for the Olympics, then in '99 for the doping committee, and then eventually, federation, who could not implement dispute resolution mechanism internally, decide to delegate to CAS their disputes. So whether at the beginning it should have been a decision by a federation to sort their dispute, which could have been appealed. Eventually, these disputes, for some of those, not the majority, went to the ordinary procedure, gave rise to an award, which then could be appealed according to the system. Now, if you look at the recent 2021 decision of the Federal Tribunal, you realize that this decision and award, in that context, specific context I've just mentioned, of federation deciding this through the ordinary course, cannot be set aside before the Federal Tribunal. It is not enforceable yet. It cannot be challenged. The setting aside is inadmissible. Why? Because there is a principle, according to Swiss law, that the remedies should be exhausted. So you go through the process of the appeal in order to be able to challenge that decision. So it begs the question, as to, in that decision, it was in 2021, it was the chamber of the anti-doping committee, and the federal tribunal, which had the opportunity to decide whether or not this was an arbitral award per se, according to Swiss law, did not do so. And it really keeps the question open as to whether or not, if you implement a system, a two-layered system, which in that case, it's the federation were rendering disciplinary decisions which were not awards. Eventually, they delegated that. That became a so-called award, which cannot be enforced, which cannot be challenged until the appellate system is enforced. It begs the question, and I think it's a question we need to, whether or not we're still talking about arbitration when the primary decision, the first decision that is rendered by the arbitral tribunal that was decided by the parties, has no binding effect, is conditional on appeal, and eventually will be replaced by the appeal decision, and thus will never exist at the end of the day. Now, by taking all these descriptions and answering your question, to try to see if there would be a system, because again, the parties may decide to do an appeal, I would argue that you would need to make sure that this appellate system fits the attributes that we've mentioned. So consent, I think we agree with Shane, so that needs to be something that is agreed between the parties. I do believe also that rules of neutrality and choice by the parties of the arbitral tribunal should be respected at the appellate level. That would be also in line with, I think, the definition we agree upon of international arbitration. I think the scope of review should be extremely limited. And again, it should not be a de novo review. It should be limited in scope and in time. Because again, my biggest concern in all the reform that is being discussed and all the potential alternatives, appellate system, is that it affects what I believe today to be the strength of arbitration is the efficiency of the enforcement of arbitral award. You would also need to make sure that there is consistency and what is the interaction between the first award, which is an award, which has been decided by the parties, which has an effect, and the appeal award, if we call it this way. I would believe that if the appeal is dismissed, then why should the appeal decision be the award, which should maybe give effect to the initial award that was rendered by the parties? Now, that's easy when it's dismissed. Now, the problem is imagine you take a limited scope. So you say it's only manifest, obvious mistake in law or in facts. I would disagree that it should be that broad, but imagine you take that decision and the appellate arbitral tribunal renders an award in this respect. Is it just revising it? Is it rendering a new award? So all of these questions will need to be decided, but I feel that what has been decided in most of these jurisdictions by denying any effect to a decision that was in the initial decision decided by the parties to finally settle their dispute, if you deprive this first award from any effect, that would go against, I imagine, what would be the main attribute of international arbitration. And there are, of course, other conditions, but I think these are the main elements I would want to see if we were to discuss. And of course, a system that will also be able to make efficient enforcement. There are remedies that are considered, whether or not, if you go through this appeal, you renounce setting aside proceedings. That is a possibility. Of course, this should be allowed into the relevant domestic system. It's allowed in the Swiss law, it's allowed in the French law. It's not allowed in every domestic system, so that is also another element. But I think that we should, in all of these appeal discussions, efficiency should be the priority, which today I think is what lacks the most.
So according to you, all the types of appeal mechanism already available are problematic, or there is?
Yeah, yes, I think that all of what I've seen today is problematic. I think we could all agree that some are more problematic than others. I think that Shane discussed judicial review. I would not, well, the English system and the Australian system, which are very similar, are very limited in the sense that parties, of course, can opt out. So the simple fact of choosing ICC rules to govern your arbitration, or RCIA, there's an automatic waiver to this kind of appeal on basis of Article 69 of the English Arbitration Act. But I think my biggest concern is when you come from the litigation. I'm a litigator, so I litigate a lot before French courts, but also other courts, is that you know that it's not only the advantage, the purpose of arbitration is getting the dispute resolution outside of the judicial system, getting it back to review the merits, even in a limited manner, to the judicial system, which has all its various recourse to the Supreme Court, remanded back to another court of appeal, is something which, in my view, brings us back 100 years ago to the Geneva Convention, to the double exequatur, where you could not do anything with an award until you had reached the final stage of the recourse at the seat of the arbitration. So judicial, I would say, maybe is what I would say is most shocking. Now, if I look at other possibilities, and without describing specific reforms in particular, I think that I've not seen today something that preserves the autonomy of the parties, the choice of the parties, and I mean all of the parties, the neutrality of the arbitrator, of the arbitration, if it's, for instance, in an institution which composition is decided by, I will take investment arbitration by states, but the investors, of course, have no saying into the composition of the arbitral tribunal. But more importantly, I think it's the finality, is how does the system will render the arbitration more efficient than you can, as it is today, enforce an award as soon as it is rendered. Once it's signed and you receive it by the arbitration institution, you can enforce that award. I don't see any benefits in the system I've seen, except, and that is something that has been discussed, if, of course, you want to renounce setting aside, but of course, this is very tentative, because the reality is that whatever you do, and ICSID system has taught us this, you'll never have a system that prevents any control from an illegal system. You will always have the public policy, which no state will ever renounce. So you have a system where you're adding layers. You can't eliminate all the controls thereafter. So you would, in any case, always be on a 2-, 3-tier system of control, which in my view would go against the efficiency of arbitration.
Jane, on this point? Yes.
Sure, yeah, I think that from what I would suggest is we need to be cautious about attributing some of the benefits that some people find in the existing system with being attributes of the system. So Ben had been mentioning efficiency. There are certainly a lot of parties that would say that the idea of choosing arbitration, or their motivation for doing that, is an efficient dispute resolution system. Now, for those of us who practice investor-state dispute resolution, we might wonder how efficient it is anymore, but that might be a motivation for actually choosing that sort of thing. But it is, in a sense, what I would say is that's a motivation. That's a value that you're placing on a benefit of arbitration, as opposed to being an inherent attribute of arbitration. I would agree there are certainly some approaches on appeal that we might have a very vigorous debate about whether they are in fact a good idea. I think Ben mentioned, an approach that allows a de novo review of issues on fact and law, essentially just a second hearing. Is that where you really want to take an appeal? Is that a useful way to adopt it? I think that probably if parties were considering it, they'd probably receive advice from their lawyers telling them perhaps not. You might want to rethink that. But it's, and I understand as well that certain approaches on appeal, like that allow points back to domestic law, like the English Arbitration Act, the Australian Act, these have their detractors. They have people wondering whether or not this is the way to go. But again, what I would say is we have to carefully separate the ideas of, is that type of appeal advisable? Is it a good thing? Or from the question of whether, is it possible? Is it still possible that an arbitration with that sort of procedure is still considered an arbitration? And I would suggest we have arbitration located, place of arbitration in the United Kingdom, one of the more popular places for arbitration. Even if it's not under, you haven't waived it, you have the option of allowing that appeal. The parties have that option. I don't think we don't think of it as arbitration merely because they have that option. I understand Ben is questioning that. I would suggest that what we are doing there is we are assuming that a value placed upon receiving an enforceable award at the end of the first phase of the arbitration is in fact an inherent attribute of it. And I would suggest that that's in fact not the case. the fundamental nature of arbitration, which is a private consensual dispute resolution process respecting party autonomy, is ultimately the same regardless of the type of appeal that you use. And so I would suggest that it really doesn't matter what type of appeal there is. There are plenty of questions to be asked in designing the procedure. Remand is an important question. It's one certainly that in the context of UNCITRAL that there's been a lot of question about. Remand, the composition of your arbitral tribunal. This has been subject to a great amount of debate and reform discussions for appeals. Is it a standing tribunal appointed by states? Is there roles for investors? All of these things, but these to me are design attributes. There isn't one question that says the answer must be this because otherwise it will not be an arbitration. The parties to these cases, the parties that are doing them, they may have selected, but they certainly think they're doing arbitration. That is what they are choosing to do. And again, I come back to, we can have lots of debate about whether or not efficiency is the key, whether we should be looking to enhance efficiency at the cost, perhaps, of correctness or at the cost of consistency. And that can be a debate but that debate is about the advantages or disadvantages of certain choices parties might make, as opposed to about whether something really is arbitration or not.
But in particular, because when we look at the surveys available, they say always that parties are complaining because arbitration is very costly and very long. And the answer to that is to add the possibility to appeal.
So certainly when, in the context of, I'll say, investment arbitration, I'm not sure it always translates to commercial arbitration, but certainly in the context of investment arbitration, one of the major concerns that was noted was that the costs are too high, the duration is too long. In fact, some of the initial work done by UNCITRAL was on exactly these topics. When the question comes up as to, well, do you add an appeal? You are adding a layer of review. Those delegations, those parties to these arbitrations who want to add that layer, acknowledge that a layer of review is being added, acknowledge that there will be time, that there will be cost to doing so. But again, it gets down to that balancing that parties can do. Is the cost and efficiency of arbitration of greater value to you than a procedure that they see as able to better ensure the consistency and correctness of decision? So it comes down to a value judgment made by the parties as opposed to something that's inherent somehow in the nature of arbitration.
And would your position on the opportunity of an appeal vary depending on whether we're in presence of a commercial or investment arbitration? Or?
So I think obviously there are differences between the two types of arbitration. You know, in a commercial agreement, I think Ben sort of referenced this, you have the two parties to the contract who will also be the disputing parties. They are agreeing on a procedure. In the context of investment arbitration, you have either it could arise out of contract, in which case it's the same. You can have investment arbitration arising from legislation. If it comes from legislation, essentially it is a state in the legislation who will determine the procedures, and that becomes a unilateral offer to arbitrate that the investor must accept. And in the treaty context, it's interesting because, of course, you have the two state parties who do negotiate what the procedures will be, and they come up with their procedures, and then it becomes a question of consent. Does the investor consent to the arbitration and consent to using the system? But the offer is on the table. However, I think in a key sense, that is always the case. One party to a contract may say, having an appeal to me is non-negotiable. It's not, if you want arbitration with me, it will be subject to an appeal. That's non-negotiable for me. And that becomes, therefore, a condition of the arbitration offer in the commercial case. In the investment case, where it is a state or the two states who might be negotiating this and then offering a type of arbitration, it is still that offer of arbitration, conditional upon procedures that the investor has to accept. But the fundamental idea that one party is conditioning its consent to arbitration on certain procedures, including an appeal, is still there, and it is for the other party to accept. I think that none of these issues or these differences, though, between commercial and investment arbitration are really all that critical to the question about the nature of arbitration. I think that we have to be careful here in answering this question to not confuse, again, the values that might motivate parties to select arbitration or with an appeal or without. Because in commercial arbitration, perhaps some of that value calculation is different. Perhaps the calculation that the parties to the investment or to the commercial agreement might make is going to be different than in a treaty. In the context at UNCITRAL, what we have seen is a number of states emphasizing that for them, one of the concerns that leads to the desire to have an appellate system is a lack of consistency in arbitral awards interpreting the same language, same treaty, just different cases, maybe a slightly different treaty. They put this forward as a reason. In a commercial arbitration case, perhaps that's not an issue, right? In a commercial arbitration case where you have two parties, there's one contract, there might not be repeated cases, consistency might not be that much of a value that the two parties to that arbitration agreement might want to have. In terms of the correctness of award, they may value efficiency. They may value the one shot. In the context of investment arbitration, the correctness of awards has taken on a much larger importance simply because of the amount of money at issue, simply because of the public policies at issue. But again, these to me are what might motivate parties to select arbitration with an appeal or without. What might motivate them to make the choices they are not, but that there is nothing in the nature of either commercial arbitration or investment arbitration that mandates the choice of whether you have an appeal or not be different from one or the other.
Well, yeah, often in the context of the reform, we've been distinguishing investment arbitration and commercial arbitration. I think the debate is largely dogmatic. If you have a conception of international arbitration as a whole, as a system, as an autonomous legal order, which has different subsystems, which have specificities, but which all rely on the same inherent principles, you should not be distinguishing between one and another. And so the criticism that could be made to investment arbitration are likely to be also raised in commercial arbitration. Consistency is raised in the context of investment arbitration, not substantive protection of whether fair and equitable treatment, umbrella clauses, most favorable nation clause. But the same could be said on commercial arbitration when the questions of extension of arbitration clauses to third parties and all the concepts which can have an impact on the decision. The reality is that in both cases, what the criticism and the fact that we're discussing about appeal systems and reform is because whether you want to say what do you do when you have inconsistent decision in the system, or whether you have wrong decision, plainly wrong decision, whether or not the system can support that, or whether the system should be changed to allow for a remedy for that. And I think in this respect, the answer to both systems is the same. I think inconsistency is an inherent feature of any legal system. Talking from a French litigator's perspective of having to go before the courts of appeal of Paris, Lyon, Marseille, and then going to the Supreme Court and having cases remanded again and seeing that the same provisions of French law are being applied in a very different manner by different courts, and often also interpreted in different manners by different chambers of the French Supreme Court, and sometimes by the same chamber of the Supreme Court. I think that you get to agree that inconsistency is amongst there. Where, however, I think we need to be careful is that the more things have been evolving, the more we've been discussing appellate systems within the investment arbitrations, justifying a specific treatment for investment arbitration. And I don't think the reason, and again, there's a lot of debate and it's dogmatic. I can give you my position where I don't think that there should be a difference between the fact that it is said that in investment arbitration, you're applying international law, the question is state liability, or there's public funds which are at stake. I think you can have the same thing in commercial arbitration, where you have a state-owned entity where the amount at stake are very important when the dispute is about energy or environmental issues, where there's corruption allegations that are raised. I think that both raise all important issues, and distinguishing one compared to the others or trying to apply a decision that is different for one another is not justified. What I want to say, and maybe this is where well, we may have disagreements, but I think that the search for an alternative that we are considering in the various systems, I was not putting in doubt whether or not having a non-binding award which is appealable is arbitration per se. I'm raising concerns in this respect, and I'm wondering what we're trying to achieve is an international, and let's say for investment. Let's now give the example of investment because it's easier when you talk about a reform, because theoretically you could consider putting all the state into a multilateral convention, decided to create an institution with judges appointed by states and by a second layer. This may not be arbitration, maybe something else. We're trying to push this into being arbitration, and my concern is creating these layers and going against what I consider to be some of the attributes, because it's not advantages. Appointing your own arbitrator, having a neutral arbitration, all these are not only advantages. I think they're part of the attributes of international arbitration. Whether or not it's actually arbitration. It's another, in my view, it may be considered more as another dispute resolution mechanism, but not try to fit in it or push it in a system, because according to me, and having worked a lot about how much the New York Convention has contributed to the development of international arbitration, efficiency is a key attribute of international arbitration. And any reform that disregards that, or that tries to find a system which will render international arbitration less efficient, goes against this essential attribute, goes against finality.
You mentioned several times the particular situation of investment arbitration.
Yes.
And within the framework of the UNCITRAL Working Group 3, and of course I am talking under the control of Jane, but what I heard sometimes is some countries which are ready to keep arbitration alive, provided that there is a way to an appeal. And my question here would be, is there any other way to cure wrong, provided that there are wrong awards, different than appeal?
Well, actually, I think that, and that is maybe where we will disagree the most, is that I would consider that the existing remedies are sufficient or can be improved, but that there's other ways than going to an appeal. First of all, I'm not sure I agree on the fact that whether in investment arbitration or in commercial arbitration, there is something that needs to be cured. There is such an inconsistency and such wrong decisions. If you take this into the perspective of the thousands of awards which are being rendered every year, which justifies changing something. I'll stay with that premise, but let's say that there is a wrong decision. What does exist today, or what could be improved, what exists today that could change that? And of course, you have the setting aside proceedings, and setting aside proceedings, which is the recourse to safeguard the integrity of the system. So when due process has been breached, if the parties have not, the arbitral tribunal has not complied with the law selected by the parties, which would be breaching its mission. If it's decided in equity when it should have decided in law, if it made a mistake into jurisdiction, or if it has rendered a decision that is contrary to public policy. All of that is covered by setting aside proceedings, which in many cases would allow to annul, if need be, a decision which would be wrong as a matter of principles, as a matter of jurisdiction, and others. Now, there are other ways. There is revision. So we know that revision is something that is not applied in every jurisdiction. ICSID has, with Article 51, a revision mechanism, but we know that it's not being used a lot and it's very restrictive. Some model law, countries that have implemented the model law have not provided for revision, but you have France, the Netherlands, you have Switzerland, you have Spain, you have England, would provide some kind of revision. So what do we mean by revision? Is if there's new facts, new evidence, which after the award was rendered, that may have an impact on the outcome, are revealed, and whether or not this would allow you to ask for the revision of the award. So of course there are differences between countries. France would allow revision only in case of fraud, and the case will be brought to the arbitral tribunal if it can be reconstituted. So it's you bring the revision to the arbitral tribunal that has been appointed by the parties. Other systems, such as the Netherlands, have revocation proceedings, which in itself is broader. It's not only for fraud, it's also for new evidence that will reveal. That's the case also in Switzerland. So you have a way, and if you believe that there's something that got wrong because potential evidence that or that is very likely or that will be shown to have had an impact on the outcome of the case, that is something that can be raised, and that's something that can be further discussed and eventually adapted. Now, all leaving these existing remedies aside, I really want to ask a question, and I'm going to make an analogy with the New York Convention. 20 years ago, there was a debate as to whether or not it should be reformed. It should be reformed because some said that there were some bad decisions and there were some contradictory decisions. Irrespective of the fact that maybe this concerned 2% of the awards that had been rendered, that raised a lot of debate. And at the time, Emmanuel Gaillard made an article on the urgency of not revising the New York Convention. And its triple no was there was no need to revise the New York Convention, there was no hope to achieve a better result, and there was no danger in leaving the system as it was. And I've made the exercise of looking at this in our perspective. I know that there's been a number, if I take on investment arbitration, a number of discussion as to whether or not there was a need and there was inconsistency that justified the reform. That was a discussion that took place many years ago, and I would welcome us to revise the question today and to assess that today. But the reality, if you look at it from the perspective of the New York Convention, is that what has achieved today harmonization and uniformity is publicity, is the fact that decisions rendered all around the world are now freely accessible, can be easily accessed all around the world by lawyers, by judges. And the impact that has been is that you've seen more and more judges recognizing awards in the world referring to cases from other jurisdictions. So relying upon the findings of other courts. That has been rendered possible by publicity. In investment arbitration, Ancetral has done a tremendous work on transparency with the 2013 convention, the Mauritius Convention, and you see the results already now. And on all of these issues of fair and equitable treatment, expropriation, how much now investment arbitrators rely upon other cases, is not as a precedent, not as something they're bound, but something that they're, at least in a very implicit way, convinced that they should at least take under consideration and sometimes follow. And the more we favor that exchange of information, that publicity of award, that transparency, that would achieve, I think, much better results than trying to change a system, and I've seen that from the New York Convention perspective on public policy, Ground 52B. If you look at the drafts of the New York Convention, there was no intention to define public policy. You would leave that to the discretion of every court at the place of enforcement. And there was no objective in the spirit of the draft of the New York Convention to achieve uniformity. At the time it was, let's get as many awards recognized as possible. When you look at the case law now, in multiple jurisdictions, you find exactly the same wording and the same elements that fit into public policy. Of course, there are some differences between some countries, but in reality, most countries have interpreted that public policy within Article 52B is considered to be the highest value of a country, not domestic public policy. It needs to be these core values. And that is something that you see consistently, and you see more and more countries referring to one another, referring to the cases. So my point is not only that the existing remedies are efficient and allow to sort, or at least to solve many of the problems of bad decision or other that exist, but if we want an efficient way of solving the rest of the problems, I think it goes through publicity, it goes through transparency, it goes to training and to conveying and to debates between practitioners, between judges, between arbitrators as to how things should evolve. And I think that's the way I would suggest, then, rather than changing a system which has proved to be very efficient.
You have maybe, yes, you can say the captain to wait a little bit because it is 8 o'clock already.
It's leaving already. It's leaving already.
So go ahead.
think we're beginning to stand between everybody and cocktails, so perhaps we don't want to be too long. I do maybe want to follow up on something that you noted, Diego, which is there are a number of groups that have sort of come out, or categories of states that UNCITRAL are in the discussion. So there are those who, much like Benjamin has said, that we in fact think they have the tools already and they don't support creating an appeal mechanism of any sort. They think the tools exist already, and I can talk a little bit more about that. There are those who do want to keep the first instance of ad hoc arbitration like the system exists, but they do want to create an appeal mechanism. Typically, they talk about a standing appeal mechanism, but also on the table, there are also ad hoc appeal mechanisms. And you've had a number of states say, we just want some sort of second review. Then there are a number of states who say, we'd actually like to create a standing permanent appeal mechanism and perhaps even associated with a standing first instance mechanism, something that looks much more like a court. With respect to the first, there are a group of states who say we have some of these tools already. And Ben has mentioned some of them in the context of investment. So transparency, I would fully agree. I mean, I had the pleasure of negotiating the Transparency Convention for Canada, the transparency rules. I was able to attend the Mauritius signing ceremony for Canada. Canada is a party to that. That, I agree entirely, is an important way to encourage a dialogue. There are other options. So, for example, greater participation by the non-disputing state party in arbitration processes so that the views of both parties to a treaty are there, possibly binding interpretations. Those, or even just non-binding but joint interpretations of what particular problematic clauses mean. There are a number of states or a number of parties to investment cases that think that those mechanisms are there. They have also pointed out to a need to increase the level of advocacy, to increase the level of the work in drafting the provisions. There are reforms that are ongoing at UNCITRAL that seek to address that. We have drafts of procedural rules that allow some of these to be applied to older treaties that don't have them. We have an advisory center that's coming to the Commission that will seek to assist states, least developed countries, in making sure their advocacy is sufficient. I encourage, of course, all states, if they're listening, to ratify the Mauritius Convention and apply transparency provisions as well. The issue for those states who see all those things as good, they are important reforms, but in their mind, they are not sufficient to address what they need an appeal to address. I think Benjamin raised something a little bit earlier that we don't know the extent of this problem. This was discussed at UNCITRAL. It does seem like a lifetime ago. I think it was in the 2017 to 2019 first phase of reform where states agreed by consensus that there were concerns with what was called unjustifiable inconsistencies in awards. This may not be, and I don't pretend to have any data, nor has anybody tried to do it probably, and it would be an impossible task to find the extent of the errors. And I think that the reality of that is law and legal decisions are not like math. There's no necessarily obviously right or wrong answer. From where I'm from, if you ask 100 lawyers about the latest Supreme Court decision, 50 will say they got it right and 50 will say they got it wrong. So you're never going to have an exact understanding of how much of a problem this is. But what the sense of delegations in the room has been that considering the importance of investment arbitration, where it is challenging issues of high policy, considering the sums involved which can alter the budgets of states on important issues, that there needs to be a further check put in place. And for those who support an appeal, that's why what we have now is in fact not sufficient. They also point out that in fact much of this already exists, and it hasn't in fact corrected some of the problems. So I think that understanding that and understanding that there are some tools already, there are those delegations in the group who fall into those second and third categories who have looked at the tools, and we had extensive debates about these tools, and they say no. In fact, those tools are not sufficient to address our concerns. They haven't worked to date. And in fact, the issues here are more endemic to the nature of the current investment arbitration system, which sees ad hoc panels which don't naturally produce consistency, and tribunals which, because there's no subject to appeal, feel that maybe unbound by or deciding things on the equities of particular cases as opposed to a strict Vienna Convention interpretation of the treaties pursuant to the intent of the parties. So again, I think that from my perspective, there can be many debates and arguments about whether that's right or that's a wrong perspective. But what I can say is that certainly in the room for those delegations who do want to retain arbitration, the idea of entering or allowing an appeal for that is not in their minds altering fundamentally the nature of arbitration. It is putting this second layer in with recognized effects on cost and efficiency, but in the investment arbitration context, there are those in a number of delegations who are valuing the consistency and correctness that they believe, at least, that this appeal system will bring.
I don't know if we have time to have a couple of questions on this. I see, before I say that, I saw already one hand. Please, go ahead.
So, Mike.
Sorry, it's a matter of habit for a British lawyer to always stand up. Firstly, I mean, you talked about key objectives in terms of arbitration, party autonomy, you talked about expediency, and certainty is the key thing as well for the parties involved, so that you can move on. In an environment like construction, arbitration is happening all the time. You get your award, you keep on with the project, you move on. I just want to revisit a couple of points, if I may. Firstly, the public law principles behind judicial review, and drawing an analogy and application. Firstly, let's unpack the principle of the public law judicial review premise. It's that the public decision maker is best placed, having a hold of the budget and so on, to make the decision. Hence, a court has a very restricted remit or locus in which to be able to review that decision for reasons of procedural impropriety, unreasonableness, etc., etc. I think that that premise myself has a parallel to arbitration in limiting the scope, and you've mentioned a number of cases. I think a common exasperation, if I may say, that you've both expressed is the inconsistency of decision making. If I'm being facetious, I'm saying bring on AI. No, I mean, I don't want to be flippant to my fellow judges. I'm a part-time judge myself. But it is exasperating, to say the least, the inconsistency of decision-making, the incoherent nature sometimes of decision-making, and that has to improve. Very finally, what I would say could assist, and this is just my observation from the outside, is this: better case management. So let me explain.
Oh, but
Yeah, right.
please, not a lecture.
Yeah.
Just,
But the arbitrators often can come from very academic backgrounds, and I think that shows, because they can treat issues so theoretically without having regard to procedural points, and sometimes they act as the procedural points are behind them. Now, the best judges combine both. They have a good knowledge of the substantive law, but they are very hot on procedure, and they're tight on procedure, and they don't allow nonsense to carry on in courts. They're very robust, and I do think that's an extra, that's needed. So my question in summary is, given all the points I've made, I'd invite your opinions. Thank you.
thank you. Do you have something to say?
I'm personally not frustrated by inconsistency. I think that, again, I've started by saying consistency is part of the system, so it's part of any judicial system. And to be fair, when you have a case to defend and you're not in the best position, you kind of hope that there is some inconsistency in the decisions that will be rendered. Now, again, it's a point that is, when we talked, by the way, about transparency, Shane, I wanted to react to that also, is that we often talk about transparency into publication of awards or procedural orders. But it also would be also to produce the submission of the parties, because if you have an award, a decision by a court, typically before the Court of Appeal, the Court of Cassation, interpreting the French decision or a Belgian decision or Luxembourg decision without seeing how the parties have actually argued the case is extremely difficult. Because sometimes without the submissions, it doesn't make any sense. And when you take also for courts, I'm giving you the example for courts, but I take the example about arbitrators, and some of the wrong decisions that we may be all thinking about in arbitration often comes in the way that it was argued. And there's no way in changing that, but at least it's a way to understand why such a decision was rendered, because sometimes the parties haven't just raised any of the arguments. Now, in that case, you would hope that an arbitrator, as a judge, would raise the questions, the good questions, and even though the parties have not argued that, they would themselves raise it. But in reality, it will always depend on a human being and different human beings taking different decisions. So it's very hard to. But I'm not criticizing the inconsistency, and I don't think that there's any frustration in that. I think even for you, Shane, it's not the fact that there's bad decisions, it's that can we live with that, or the states that have been acting don't want something more because they feel that what exists today is not sufficient.
Yeah, I would say, on the question of inconsistency, there was a lot of discussion about this in the working group, and there was a lot of sympathy with what Benjamin is saying, that sometimes a decision that you look and say, well, how could they possibly have decided that? And then you do look at the pleadings, if they're available, and Canada does publish its pleadings. You do look at the pleadings and you say, oh, well, because that's what they argued. That's what the parties engaged on. So there were tools that I talked about, including sort of the advisory center that's designed to help states in ensure that. But there is another layer to that, which is even with the discussions in the working group, the 110 states that typically come, we're still able to reach consensus that there were some instances of concerning unjustifiable inconsistency, inconsistency where it did not come down to legal arguments, and those were sufficient to allow the states that come to say, in fact, we agree there should be some sort of reform here. What those reforms are and whether it's an appeal mechanism is different. The only other thing I would say is on the point of certainty. I think, as I said at the beginning, yes, ultimately one does need a final and binding decision that can be enforced. The question really is, when do the parties choose to have that certainty? Do they choose to have a one-shot thing, as Marina said right at the beginning, or do they choose to have some sort of appeal in their arbitration process that might delay that certainty? And Benjamin was mentioning this might be delay somehow the enforceability of the final award, but to do that to achieve other things that they do hope to achieve by having that process.
Any further question? Please, Sophie.
My question is that party autonomy is an essential attribute of international arbitration that goes without saying. And the ability to have one's own, select one's own arbitrator at the very first stage of proceedings is again, an essential part of that party autonomy. What happens at the appellate stage when the arbitrators are not essentially chosen by the parties?
I think I'd respond just by questioning actually a little bit the premise, which is that is the ability to choose an arbitrator an essential inherent attribute of arbitration? It is certainly the way that it's been done to the past, but it is not necessarily inherent that that is an aspect of party autonomy. It may be an important aspect that many parties do value, and I've certainly heard in the context of UNCITRAL that many parties put great value on that. But there are others who don't, and there have been numerous systems that have been proposed of reform that talk about other ways that arbitrators could be appointed, which would include possibly having rosters and third-party appointment from rosters. There have been criticisms of the party appointment system. So I think I would start by saying, I think we need to question whether that is actually an inherent attribute. At the appellate level, again, what is currently being discussed is a number of various options. One could imagine a system of appeal in which there was, in fact, appointment by parties to the dispute. One could imagine a system of appeal where it is a standing mechanism where there are 9, 18, whatever you want to have it, judges, appeal arbitrators, annulment committee members, whatever you want to call it, that are appointed by some neutral third party. In the ICSID context, the annulment committee is appointed by the Secretary General. There is no party selection. So there are various different options, I think, that could be considered as to how such appeal tribunals might be composed. And certainly in the context of UNCITRAL, there's still a lot of discussion as to what that might look like.
And I fully agree with Shane on the fact that there's not a consensus on whether it is an attribute of international arbitration. And on that point, I just wanted to react on one thing, Shane. You said the fact that we're delaying the decision, the enforcement of the arbitral award. And I think the point, and maybe this is something for reflection, is that actually I understand that in the current system, we're not delaying the first award. We will be replacing the first award. Or at least that is what is existing for the time being. And that's why the connection between the two and whether or not it's actually an award per se, or if it's something that is an award which is subject to appeal, which at the end disappears from the legal system because it's deprived of any effect. I think that's where we're saying that, again, we can name it different ways, but at the end we need to make sure if the concepts actually work. Now for the consistency, and this is the last point I wanted to make, is that I know that there's been a lot of discussion on consistency. And maybe since 2019, the focus is not now on whether or not there's a need to change it. It's more on how do you reform. But since then, there's been hundreds and thousands of awards which are being rendered every day, and some of which we've just discovered, which are old awards, but now are being published. And I still believe that, and this is what we've done at the time for the New York Convention, but we can do it for any convention, whether or not it's useful at some point on the main, the topics which were umbrella clause or MFN or whatever, whether or not there's a need to reassess, because I feel that on some of these topics, and now it's really from a practitioner perspective, there has been a lot of changes and a lot of going into the right direction, and it is worth at least raising, because I think that this is genuine. It is a reality that things are changing. Awards are being rendered more and more, and potentially some of these topics which were once so concerned may have evolved in a positive manner.
I think the additional questions have to be put during the navigation. Otherwise, we will stay here without this part, which is a very wonderful part of this exercise. Thanks to JVS. And I would like to thank, on behalf also of Marina and in general of the Arbitration Academy, thank you very much, Shane. Thank you very much, Benjamin. I think it was very, very interesting.